Hey, what's your name?
Why?
Because you match a description. I need your ID.
What description?
Don't start, just hand it over.
Am I being detained?
You are now.
On what grounds?
Suspicious behavior.
Buying groceries?
Turn around. Hands behind your back.
Michael Aaron was doing nothing. That is the part that needs to be said plainly before anything else, because the story that follows only makes full sense when you understand where it begins. Not in a courtroom, not in a news cycle, not in a press conference where careful people choose careful words, but in the snack aisle of a public supermarket in Tallahassee, Florida, on a Saturday afternoon in March, where a 41-year-old man in a dark olive hoodie and jeans was carrying a small grocery basket containing a carton of orange juice and a loaf of bread, and doing absolutely nothing that warranted what happened next. Michael Aaron had been a Florida state attorney for 6 years. Before that, he had spent 4 years as an assistant state attorney, building cases against the kinds of crimes that required real evidence, real witnesses, real legal architecture. He had prosecuted violent offenders. He had argued before appellate courts. He had, on more occasions than he could precisely count, evaluated whether law enforcement had conducted stops and detentions within constitutional parameters, because that was part of his job. Reviewing the legality of how the officers under his jurisdiction's prosecutorial umbrella went about their work. He held that authority quietly. He did not wear it. He did not need to. On a Saturday afternoon when he was buying orange juice, it had not occurred to him that he would need to produce it. What most people in that store did not know, what Officer Ricky Martins, who was about to approach him from the far end of the aisle, did not know, was that the man in the hoodie had, earlier that morning, reviewed a suppression motion filed by a defense attorney challenging the legality of the traffic stop made by an officer from Martin's own department. Aaron had read the motion carefully, made notes in the margin, and set it aside for Monday. Then he had driven to Publix to buy orange juice and bread. That was the full distance between his professional life and where he was standing when Martins turned the corner. Martins was 6 years into his own career, a record that contained 2 commendations and 1 prior complaint that had been investigated and closed without findings. He was not, by any available documentation, a bad officer. He responded to calls. He followed procedure. He had been dispatched that afternoon on a non-emergency call, suspicious person, rear aisle, male in a hoodie, and had entered the store with the focused, forward posture visible in the overhead camera footage that would later be reviewed many times by many people. Chin level, hand near his belt, moving with the particular certainty of someone who has not yet encountered a reason to slow down. The call, it would later emerge during the department's internal review, could not be traced to a verified complainant. The description, male, hoodie, rear aisles, acting suspicious, matched, by the department's own acknowledgement, at least 3 other customers in the store at that time. 2 of them were white. None of the others were approached. Marcus approached Michael Aaron and asked for identification. Aaron, who had spent enough years in courtrooms to understand that the temperature of a response can determine the temperature of a confrontation, kept his voice level. He asked, calmly, what the basis for the request was. Marcus explained the call. Aaron nodded and reached toward his back pocket for his wallet. Marcus told him to keep his hands visible. That exchange, a man reaching for his identification, at an officer's direct request, being told to keep his hands where they could be seen, was the first indication that the transaction was going to be more complicated than it appeared. It had already become a negotiation before either of them had exchanged more than 4 sentences. Aaron produced his state attorney credentials. The identification was official, government-issued, and unambiguous. His title, his office, his jurisdiction, all of it was printed clearly on the card he placed in Martins's hand. Martins looked at it. He looked at it for longer than the information on it required. Then he radioed dispatch to verify. What followed was 11 minutes. 11 minutes during which Michael Aaron stood in a grocery aisle holding a shopping basket, while the radio line to the department database cycled through what the later documentation would describe as higher than normal call volume. A store employee approached at some point and asked if everything was all right. Martin said yes. Two customers who had been standing near the cereal display quietly moved to another section. One customer remained at the end of the aisle, close enough to watch, not close enough to be responsible for anything, which is a distance that most bystanders in situations like this find manageable. At minute 7, Martins asked Aaron if he had any additional identification. Aaron, who was a state attorney and therefore understood exactly what was happening and exactly why keeping his voice flat and cooperative was the only rational strategy available to him in that aisle, said yes and produced 2 more forms of identification. At minute 9, the verification had still not come back through the radio channel. At minute 11, Martins told Aaron that he was going to need to accompany him to the station until the identification could be confirmed. Aaron said, quietly, "I am a Florida state attorney. I have prosecutorial jurisdiction over your department." Martin said, "I understand that, sir. That will be confirmed at the station." The handcuffs were applied without raised voices and without physical resistance. Because Aaron had made the decision, the same decision that a specific and well-documented calculation drives people in his position to make, that compliance in the moment was safer than assertion, and that the gap between those two things was where people got hurt. He stood still. The basket was placed on a nearby shelf by Martins, carefully, the orange juice upright. They walked toward the store's automatic doors, which opened and closed the way they always did, without ceremony. No one in the stores said anything. They took starts, and the stores were fined and fast. It looked like procedure, which is precisely why it was able to happen. 47 minutes later, Martins's supervisor, Sergeant Dana Howell, arrived at the processing station. By that point, Aaron had provided 3 forms of identification. 2 of his colleagues had been reached by phone. The main line of the state attorney's office had confirmed his employment, his title, and his jurisdiction. Howell reviewed the documentation, stepped into a side room with Martins for approximately 4 minutes, and returned. Aaron was released. Howell delivered the apology personally. It was professional, brief, and structured around a specific choice of language. The situation had been not handled optimally, not wrongly, not unlawfully, not in a manner that caused harm. Optimally, Howell assured Aaron that a review would be conducted and appropriate steps taken. The review, it would later emerge, was conducted internally, supervised by the same command structure that had trained Martins, employing the same methodology the department used to evaluate its own conduct, with findings that would not become available through public records unless someone filed a lawsuit to compel their release. Aaron drove home from the station. His car was still in the Publix parking lot. His groceries were not. They remained wherever Martins had placed the basket, or had been restocked by store employees in the intervening hour. He did not go back for them. He drove home and called his attorney, not because he was confused about what had happened, but because the documentation of what had happened needed to begin immediately and precisely, before the institutional memory of the incident was shaped by people whose primary interest was in its containment. The department issued a statement 48 hours later. It described the incident as a miscommunication during a routine response to a community welfare call, and confirmed that a review is underway and appropriate corrective measures will be taken. Officer Ricky Martins was placed on desk assignment pending the outcome of that review. The review lasted 6 weeks. The story broke on day 2. A reporter covering the state capitol beat saw the complaint filing, recognized the title on the complainant's name, and understood immediately what the story was. By the end of that news cycle, it had been picked up by 3 national outlets, shared across social media platforms more times than anyone tracked precisely, and framed, insistently, almost universally, around the irony. State attorney arrested by cop who had no idea. The man whose office oversees the department that detained him, the twist, the reveal. But the coverage did not include, with almost no exceptions, was what the review found. What happened to the unverified complainant who had called in the suspicious behavior report? What Michael Aaron said to his family that night? What his younger brother, who is not a state attorney, who does not carry government credentials in his wallet, who shops at grocery stores in hoodies on Saturday afternoons without institutional protection, said when he heard the story. The engagement lasted approximately 72 hours. Then something else happened in the news cycle, and the story settled into the archive where stories go when the internet has processed them and moved on. Aaron's attorney, a civil rights litigator named Sandra Okafor, who had spent 18 years building cases against municipalities, reviewed the video footage, the radio logs, and the department's internal documentation with the particular attention of someone looking not for outrage, but for architecture. What she found was not an anomaly. The department, it emerged through records requests and eventual deposition testimony, had no formal written protocol governing how officers were to respond when a subject produced credentials indicating prosecutorial authority. There was no training module on that scenario. There was no protocol for what verification meant, how long it could take, or at what point the absence of verification justified escalating a stop to a detention to an arrest. There was also, as Okafor would later establish through deposition testimony, no formal guidance on how officers were to evaluate suspicious behavior calls originating from unverified sources before initiating a stop. Okafor filed a federal civil rights complaint on Aaron's behalf 4 months after the incident. The filing was precise, technically detailed, and deliberately calm in its language, because Okafor understood, as Aaron understood, that the cases that produce institutional change are not the ones built on fury. They are the ones built on documentation. The lawsuit named Officer Ricky Martins individually and named the department under a pattern and practice theory. The argument that what happened to Michael Aaron was not a failure of one officer's judgment, but a failure of institutional design that had created the conditions for that judgment to operate without constraint. The deposition of Officer Martins was conducted on a Tuesday morning in a conference room with a court reporter and no cameras. Martins answered questions under oath about his training on credential verification, about the protocols governing stops initiated by unverified complaints, about whether he had received instruction on how to respond when a detained individual claimed a professional role that would place them within the jurisdictional authority of his own department. He answered those questions accurately. The answers were not favorable to the department. He had received no specific training on credential verification timelines. He had not been instructed on the scenario he encountered. He had made a judgment call in the absence of policy, and the policy's absence was not his fault. The deposition of Sergeant Dana Howell, who had delivered the apology, was more instructive. When asked whether his choice of language, not handled optimally, rather than handled improperly or in violation of the subject's rights, had been deliberate, Howell paused for a long moment before answering. He said the language reflected his assessment of the situation. He was not asked to elaborate on what that assessment had been. When asked whether the department had, in the 18 months since the incident, implemented any changes to its stop and verification protocols, Howell said that enhanced training was under active consideration. He could not provide a date on which that consideration had begun, or a projected date on which it would produce any implemented change. The deposition of the department's training director established that in the prior 5 years, no training module had addressed the protocols for stops initiated by unverified complaints. No module addressed credential verification timelines. No module had ever included a scenario involving a detained individual who turned out to hold authority over the detaining officer's department. When the training director was asked how officers were expected to navigate those scenarios, in the absence of training, the training director said officers were expected to use professional judgment. When asked what guidelines defined the parameters of that judgment, the training director said officers received general guidance during academy training. When asked whether that general guidance had ever been updated to reflect legal developments or documented incidents, the training director said updates were made periodically. He could not identify the last time an update had been made. The settlement was reached 14 months after the incident, 3 days before the case was scheduled for trial. The city agreed to pay a sum that was not publicly disclosed, in full because certain terms of the settlement were sealed, at the department's request, a detail that Aaron's attorney noted publicly, and that generated a brief second wave of media interest before the story settled again. What was publicly disclosed were the structural reforms. The department was required to implement a written protocol governing stops initiated by unverified complaints, including a verification requirement before any stop could be escalated to a detention. The department was required to implement a credential verification process with a defined time limit, beyond which a supervisor was required to be contacted and present before any further action was taken. The department was required to conduct training, to be designed by an outside contractor with no institutional ties to the department, on the legal parameters of pedestrian stops, the handling of stops involving individuals with professional credentials, and the constitutional standards governing detentions. These requirements were real. They were written into the settlement agreement. They were subject to a compliance review by an independent monitor for 3 years. Officer Ricky Martins received a written reprimand, which was placed in his personnel file. Personnel files in Florida are not public records unless disclosed through litigation. Within 8 months of the settlement, Martins transferred to a department in a different county. No information about the transfer process, the receiving department's awareness of the reprimand, or any conditions attached to the transfer was available through public records request. Sergeant Dana Howell remained with the department. He was not promoted in the period following the settlement. He was not demoted. His personnel record, if it contains any notation of the incident or his role in a deposition testimony, is not accessible without litigation. 3 months after the settlement was announced, Michael Aaron gave a brief interview to a legal trade publication covering civil rights developments in the Florida court system. He was asked whether the outcome had given him a sense of resolution. He paused before answering. He said he thought the reforms were meaningful. He said he believed Sandra Okafor had built a case that produced more structural accountability than the department would have accepted voluntarily. He said he was glad the protocols existed now that had not existed before. He was asked whether the incident had changed how he approached his work. He said it had confirmed some things he already understood. He was not asked what those things were. The interviewer moved to the next question. Aaron continues to serve as a Florida state attorney. He is, by the accounts of his colleagues, effective and precise. More precise, perhaps, than before, in the language he uses in his filings. In the distance, he maintains between his institutional authority and his expectation of what that authority will protect him from when he is not presenting it. He carries a second form of identification when he is not in professional attire. He has mentioned this to no one officially. It is not a policy, it is a habit. It is the kind of adaptation that does not make headlines, because it is not dramatic, because it does not resolve anything, because it is simply what you do when the system has demonstrated to you. In a grocery aisle, with fluorescent lighting and automatic doors and a basket of orange juice and bread, that the protection you thought you had is conditional on whether the right database is reachable by radio at the right moment on a Saturday afternoon. He no longer shops at the Publix on Appalachia Parkway. He has not explained this to anyone. It requires no explanation. The reforms the settlement required were real. The training happened. The protocol was written and implemented. The independent monitor filed compliance reports for 3 years, and the reports indicated the department met the benchmarks it was required to meet. What the compliance reports could not measure, what no document produced in the aftermath of this incident was designed to measure, was whether the unnamed person who called in a report of a suspicious male in a hoodie to a non-emergency line on a Saturday afternoon, a call that could not be traced to a verified complainant, a call whose description matched multiple customers in the store at that time, would make the same call again. Whether the next officer dispatched on a similar call, at a different Publix, in a different county, with protocols designed by a different department, or no protocols at all, would slow down long enough to allow 11 minutes to become 47 minutes to become a federal lawsuit. Whether the next man standing in a grocery store aisle in a hoodie, carrying a basket, not running, not arguing, not on the phone, simply standing, whether that man would be carrying credentials that a database would eventually confirm, or whether he would be someone whose protection from this scenario was not stored anywhere a radio call could reach. The store in Apalache Parkway is still there. The frozen food aisle is still there. On any given Saturday, there are men in hoodies buying groceries. The settlement has been filed, the training has been delivered, the monitor has completed its 3-year review, the case is closed. And if you ask what changed, the honest answer, the one that takes longer to say than the version that went viral and was forgotten in 72 hours, is that something changed for the one department, in the one city, where one man happened to hold enough institutional leverage to make the cost of not changing higher than the cost of changing. The protocol exists now. The training happened. The monitor reviewed the compliance reports and found them satisfactory. And if you ask what didn't change, that answer takes longer still. And it is the one that nobody filed a motion to compel, and nobody put in a public records request, and nobody covered in the follow-up story that was never written. What didn't change is the call. The vague complaint, the unverified description, the dispatch to the rear aisle of a grocery store where a man in a hoodie is standing with a basket, doing nothing. What didn't change is the gap, the 11 minutes of institutional delay between the moment a person tells an officer who they are and the moment the system confirms it, and what lives inside that gap, and who bears the cost of living inside it. And whether carrying a second form of identification is a victory or just the shape that survival takes when the alternative is less certain. Michael Aaron knows the answer to that. He has chosen not to say it in any interview he has given. That is possibly the most precise thing about him. If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it, and let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next.